So with that, I'd like to ask Professor Lee to introduce our esteemed guest and speaker today. Thank you.
Great. Um, Thank you, Shefali. So it is my incredible honor to introduce today's speaker, Professor Karen Musalo, who is a personal hero to me and my own mentor of many years. I have her to thank, in fact, for being here in my new role as Associate Professor of Law, as she did more than I could ever articulate in encouraging me and supporting me in pursuing a path in the legal academy, as well as in shaping my own development as a thinker, scholar, and advocate in the field of refugee and immigrants' rights. Professor Musalo is the Bank of America Chair in International Law and the founding director of the Center for Gender and Refugee Studies at UC Hastings College of the Law, where I had the good fortune of working with her before coming here. She has authored a leading casebook in refugee law and has contributed extensively to the evolving jurisprudence of asylum law through groundbreaking scholarship, as well as through landmark litigation. Professor Musalo was lead attorney in matter of Kasinga, a case involving female genital cutting, which established for the first time in US courts that gender-based persecution could be a basis for asylum. Matter of Kasinga was not only a nationwide precedent decision, it has also been cited by tribunals around the world as persuasive authority. She has since played a major role in every national asylum case extending protections to women persecuted for being women. She represented Rodi Alvarado in the matter of RA case and served as amicus counsel in matter of ARCG, successfully championing domestic violence asylum claims in those cases. She is also serving as co-counsel currently to Ms. AB in matter of AB, the decision of former Attorney General Jeff Sessions that attempted to close the door on these claims. Professor Musalo has been recognized with numerous professional and academic awards, including an honorary Doctor of Humane Letters from Lehman College. She is a true luminary in the field, and we are honored to have her here today. Professor Musalo, thank you and welcome.
Thank you, Professor Lee, for such an incredibly generous introduction. And I want to thank Professor Milzarek Desai and Professor Lawrence for inviting me, and to thank the Bacon Immigration Law and Policy Center for this series. It's really an honor for me to be here. I'm only sorry that we can't all be in the same physical space at a, but in days and years and months to come, I hope we'll be back to normal and be able to do that. So I am going to use a PowerPoint. So I'm going to share my screen, and sometimes there's some technical problems. So I ask you to all bear with me. I apologize if there's any technical problems. And I'm going to try to cover what I cover to leave enough time for us to really have dialogue. But I did try to pack a lot in here. The title of my remarks are A Failure of Protection, 40 Years of US Refugee Law and Policy. So I, was kind of trying to go from the beginning and go through to the present. So here we go. Let's see how this works. Okay. Oops. Let's see. Okay, everybody can see and hear me still? Yes, okay, great. Let's see. Okay, so I'm sort of starting from the beginning, and the whole refugee protection system came into existence in the wake of World War II, with the failure of the international community to protect those fleeing persecution. And we have the 51 Convention and the 67 Protocol, and we have this definition that probably most of you are familiar with, the refugee as a person with a well-founded fear of persecution on account of one of these 5 grounds. The US is a party to the protocol, but not the convention. And to bring the US into compliance with its international obligations, Congress enacted the 1980 Refugee Act. So that's when I say sort of 40 years, that's my starting point. And the US got off to a positive start in that it adopted the international definition of a refugee, that person with a well-founded fear. And the 1980 Refugee Act set up two procedures by which the US would protect people fleeing persecution. One by which people enter as refugees and are resettled, and the other individuals who show up at our border or apply from within the interior of the US. I'm just going to touch briefly on the first, the resettlement program, and then really spend the bulk of my time about applications made at the border or from within the interior of the US. So a lot of you probably know this process is an annual process where the president consults with the judiciary committees, determines the number to be admitted, and allocates them by geographic region, and within region name certain priority groups. And I want to put what the US has done in context of global needs. So by the end of 2019, we had almost 80 million people forcibly displaced. We have, these top origin countries: Syria, Venezuela, Afghanistan, South Sudan, Myanmar, and top host countries. And you'll see that Germany appears as one of the top host countries at this point. So putting that in perspective, what the global need is, and then what the US has done over the years, this graph, and I apologize if this makes your eyes cross, but this really shows from 1975, so even prior to the Refugee Act, it shows the numbers and the regions from which they come of individuals who entered through the US refugee admissions program. And you could see we had like a high point in 1980 with over 200,000, but really there's been, ebbs and flows, but mostly like ebbs of a decrease, with none so dramatic as under the Trump administration. And so, even before Trump, the US has been criticized for when it admits refugees through this program, it really is more influenced by foreign policy than humanitarian considerations. The majority of allocations to those fleeing communism, hardly any to Africa, hardly any to Latin America, and for not burden sharing. And so, if you look at our history on Syria, and again, remember, this is pre-Trump, 2011, 2014, we resettled 211 refugees. Then the number came up, went up a little more. And when, to his credit, in the last year of the Obama administration, President Obama was going to set the Syrian refugee number at 10,000 and the overall refugee admissions number to 110,000, which would have been the highest since 1995. But then, as you know, the Trump administration came in. There were, various efforts to totally suspend the refugee admissions program, as well as to bar refugees from certain countries. Again, if we had a lot of time, and Eunice is actually an expert on this issue, has published on it and thought a lot about it. But what ultimately happened was that the issue of refugees wasn't dealt through, the Trump administration decided to kind of take the issue of refugee admissions out of the Muslim ban, deal with it separately, and slash the numbers. And so we see a steady decrease in the number admitted. And just last week, it was announced that the allocation for this coming year is 15,000, which is the lowest it's ever been. And I give this little quote by Chief of Staff John Kelly, which I think expresses the mentality of so many in this administration. The number of refugees admitted into the US would be between 0 and 1 if it were up to him. And that's a really sad commentary to make, that this is the position of anybody, but it's of everybody in this administration. So just quickly, I want to just mention and then dismiss the justifications of this administration for lowering refugee admissions or being very having adverse position, hostile position, asserting that they're a security risk when they are one of the most highly vetted populations to enter the US, or asserting that they're a cost drain. And, studies have shown the exact opposite. And I cite this one study by Department of Health and Human Services, which found a huge contribution in revenues. And that study was actually leaked because there was an attempt, the Trump administration prevented that report from being publicly released. So that is really all I'm going to say about the refugee admissions program, but it just, I hope gives you an idea of that one route to asylum and what's happened. And now I want to talk about applications made at the border or from within the US, which is contemplated by the Refugee Act. And my kind of, thesis of this presentation, or not thesis, really like strong, proven, perspective that's proven out by just doing any kind of a research on this, that, since the passage of the Refugee Act, there's just been restrictive procedural measures and restrictive substantive interpretations that have prevented the promise of protection from being fulfilled. So because refugee and immigration issues are so tied into race, racism, and xenophobia, one of the things I like to start off with is the treatment of Haitian refugees, and which was sort of one of the earliest things after the Refugee Act, one of the first things that was done vis-a-vis refugees, which was restrictive towards Haitian refugees. So Congress enacts the 1980 Refugee Act, and immediately then President Reagan enters into an agreement with the Haitian dictator Jean-Claude Duvalier, which allows the US Coast Guard to intercept Haitians and return them to Haiti, which is really pretty exceptional when you think about this. But because we had the Refugee Act, President Reagan, in this executive order, had the fig leaf of saying that no person who's a refugee would be returned without his or her consent, which implies that there would be some bona fide screening to see if people on these vessels were fleeing persecution from Haiti, and if so, they would be permitted to apply in the US. I think the numbers bear out that this was nothing but a facade or a fig leaf, because in a 10-year period during which human rights reports showed gross violations of human rights in Haiti, 23,000 Haitians were interdicted by the US Coast Guard, and only 28 were found to have sufficiently bona fide claims that they would be allowed to apply for asylum. So what happened? Here's a story of what happened with this policy that crosses over from the Bush administration into the Clinton administration, which I think is a real cautionary tale for us all. And I think we'll see some things that we should fear with what would hopefully be an incoming Biden administration, but some things to give us some food for thought. So this is just the context. You could see that, where Haiti is in location to the US and why people might take to the boats and their destination might be the US. So what happens in 1991, there's a coup overthrowing the first democratically elected president of Haiti, Jean-Bertrand Aristide. And there really is literally a bloodbath of his supporters after that coup. And Haitians are taking to the seas seeking protection. And for a brief moment, the US halted this program of interdiction with screening, and which was a positive thing. But, and it was recognition that there were so many bona fide refugees. But then what happened was, and this was under President Bush, there was interdiction with screening resumed, and there were so many Haitians who were found to have a credible fear. Well, let me back up. So they were screened, and what you might think is that if they were going to be allowed to apply for asylum, they would be taken to the US where they could pursue their claims. But when people are on US soil, generally speaking, and again, this is a whole big area of constitutional law, they have rights. And so George H.W. Bush didn't want them to have those rights, so they were taken to Guantanamo to have their claims adjudicated. And a third of those who were interdicted at sea were found to have a credible fear and were taken to Guantanamo. And Guantanamo was quickly filling up. And these are some photos from that shameful period of time for keeping asylum seekers in these conditions. But Guantanamo quickly started to fill up, which meant that the Bush administration had to make a choice of either allowing Haitians with credible claims to set foot on US soil and apply, or to simply repudiate obligations, asylum obligations to them. So what did the Bush administration do in May 1992? It issued the Kennebunkport order that all Haitians interdicted were to be returned without even screening. So just not even that fig leaf of screening them. This is after a coup. And candidate Bill Clinton criticized it harshly, saying he was appalled by this decision. It shouldn't stand. It's a blow to the principle of first asylum, to America's moral authority, to defending the rights of refugees around the world. What actually happened? Once elected, President Clinton adopted this policy of interdiction and return of all Haitians without screening. Why? It was reported that the US Coast Guard had told the incoming Clinton administration that Haitians had built 1,000 boats in anticipation of his promise to reverse the policy. And he was so frightened about this possible surge of asylum seekers that he reversed the policy. And so I say this with a little put a little mental note about Biden's promises to reverse certain policies and whether or not there might be an increase in migration from the Northern Triangle countries. And there's a lot of us now talking about that and talking about the possibilities and how to respond to that. So what happened was this policy of interdiction and return without screening was challenged in the courts, and it ended up at the US Supreme Court in a case called Sale v. Haitians Center Council. And at issue was whether interdiction and forcible repatriation without screening and bona fide refugees violated international and domestic obligations. And so here's just a little reminder. This is the language of the Refugee Convention and Protocol, which is pretty clear: not to expel or return a refugee in any manner whatsoever. And our Refugee Act shall not deport or return. And so the attorneys for the Haitians were basically saying this is clearly a violation of our international and our domestic obligations. There was no question of fact here. For some of you who might wonder, well, was there a doubt whether these Haitians who were fleeing actually were at risk on account of one of the 5 grounds? And the Supreme Court, in its decision, accepted as an uncontested finding of fact that since the military coup, hundreds of Haitians had been killed, tortured, detained, etc., because of their political beliefs. So we even have them saying the persecution and the nexus on account of, and thousands had been forced into hiding. And in what is really a low point in our history of Supreme Court jurisprudence, in an 8-1 decision with just Justice Blackmun dissenting, the Supreme Court held that neither the Refugee Act nor the convention or protocol prohibited the policy of picking up Haitians at sea and returning them directly to Haiti without screening. So how was the problem of the Haitian refugees finally resolved? Incoming President Clinton was under tremendous pressure. The Congressional Black Caucus, refugee advocates, they were just appalled by what he had done. And so, I'm oversimplifying this, but basically how the Haitian refugee issue was resolved, the crisis was resolved, is that part of US foreign policy became making sure that President Aristide, who was illegitimately deposed from power, that he would be restored to power. And that actually stopped the refugee flow. He was elected a second time. He was forced out of power. Again, that's a whole other story. But just sort of starting off with, here's the earliest sort of examples of the implementation of the Refugee Act towards Haitians. So what was the legacy of the Sale decision? One is that it emboldened other countries to adopt policies that deny access to their territory, just as the US had done. So Australia, beginning in 2001, began this offshore processing of asylum seekers, and their legislature actually mentioned the Sale case when they adopted this policy. And then within the EU, we've seen countries closing their borders, trying to outsource their refugee obligations. And then in the US law, it really paved the way for this idea of expedited removal, which was part of the 1996 Illegal Immigration Reform and Immigrant Responsibility Act, where no longer would people be able to just access US territory and apply for asylum as had existed in our laws since 1980, but now they had to establish that they had a valid enough claim for them to be able to apply for asylum. So this is, sort of on the level, sort of big picture procedural, even accessing the territory. So now I want to focus in on Central American refugees, because this is another example of failed promises. And it's so connected. It's like we're looking at a full circle for people like me who, have been around doing this work since the 1980s. And we see this sort of, now the focus is again on Central American refugees, and we're doing many of the same things towards them. And it's even more egregious because, as I'll talk about, part of the current conditions that are so difficult for Central Americans, we have responsibility, for them in certain ways. So again, this is sort of a lightning fast run through very complicated issues. But so civil wars in El Salvador and Guatemala in these extended time periods with massive human rights violations led to many seeking asylum, beginning in the 1980s when we had just enacted our Refugee Act. And these are just some, images from the period. This is the opposition in El Salvador, the guerrilla and popular movement, who were being decimated and saying you could pull out the flower, but the roots will sprout new flowers among us. And then in Guatemala, again, just an image, where there were incredibly widespread genocide against the Mayan people. And this banner that says 626 massacres of indigenous villages, and they still deny there is a genocide. So pretty horrific things that happened in both El Salvador and Guatemala. The US supported repressive regimes in both countries, funded their military. Those of you, again, if we had more time, could go all the way back to 1954 and the US deposing Arbenz, who was he was a president of Guatemala who was really trying to address economic inequality and discrimination. So US really supported these repressive regimes, and that reflects a biased asylum policy. You don't want to say that your friends to whom you're giving money, that those friendly countries are killing their citizens. So what you have to do is deny protection. And so in the 1980s, virtually no Salvadorans or Guatemalans were granted. And there's some, reported grant rates of 2.6% grant rate for Salvadorans, 0.9% for Guatemalans. And then as now, pressuring Mexico to stop the flow of Salvadorans and Guatemalans to the southern border. So again, this is a little bit of a history lesson for those of you who weren't around then. There was this kind of discriminatory adjudication gave rise to a lawsuit, ABC v. Thornburg. And the US entered into a settlement agreement rather than having the case go to trial. And the US agreed that foreign policy and border enforcement, or whether the US agreed with the political or ideological beliefs of the individual seeking asylum, was not relevant to a grant of asylum. So it was actually acknowledging that these very things that were underlying this biased adjudication were not legitimate. So you had that acknowledgement, but really at the same time, you're seeing adjudicators either urging or adopting restrictive interpretations of the refugee definition, which resulted in denial of protection nonetheless. So moving forward in history from sort of, Guatemala, El Salvador, and also Honduras then to now, and again, a gross sort of oversimplification and sort of shrinking of things, but the civil wars came to an end. But the root causes of the conflict, the reasons they were fought, weren't resolved. So extreme income inequality was not addressed. And the violence of the conflict, which, was committed with impunity without real real, punishment. There was so much amnesty and impunity. It left scars on society. And so we now see that El Salvador, Guatemala, and also Honduras have some of the highest homicide rates and femicide rates in the world. And I always want to talk about like the civil wars and other interventions when I talk about high homicide rate and femicide rates, because I think it's very important not to sort of say, hey, these are violent countries. What's the matter with these people? Like, what is it in their culture? Because these are very complicated issues with colonialism and the conquest and, intervention, which really all come together, to explain these high rates. And the US responsibility, particularly with economic inequalities and policies that the US has supported, deporting immigrant youth from the US who had been involved in gang activity, which really deporting them back to countries that didn't have the ability to integrate them and rehabilitate them. And we see, the rise of gangs. And the US, in Honduras, using Honduras in many ways and intervening and undermining its democratic institutions. So for all three of the countries that are now main origin countries for the asylum seekers arriving at our US border, the US certainly has a dirty history and a moral responsibility. And if you add on top of that, climate change and multinational resource exploitation that has affected these countries. And again, if we had more time, we could go into sort of that and responsibility of US and Canada and Australia, other countries that have been exploiting resources and contributing to the bad conditions. So, okay, so we have this historical context. What I talked about earlier was sort of procedural barriers, sort of historical context and bias. And now I want to just take a very short sort of overview of the development of the substantive decisions, like how has the refugee definition of a well-founded fear on account of, how has it been interpreted so that it has actually resulted in a failed promise of protection? And again, it's going to be a lightning speed run through really complicated issues, but the very earliest Supreme Court opinions in the 1980s, and those of you who study immigration, and these cases, Stevic and Cardoza, they brought the US into almost an immediate conflict with international norms, because international norms, the standard is that anyone who can establish a well-founded fear, which is like a 1 in 10 likelihood of being persecuted, is entitled to not be returned, is entitled to non-refoulement. And the US imposed a higher standard for non-refoulement, which is more likely than not, so 51% or more. So that, in the earliest days of interpreting the refugee definition, the US held that not all refugees are entitled to non-refoulement. Then on the nexus requirement, so the persecution has to be on account of one of the 5 grounds, what we lawyers call nexus. And in INS v. Zacharias, the US Supreme Court again rejected international norms to impose a very hard and difficult requirement that persecution is only on account of, or nexus is only established if you can prove that the motive, what was in the head of the persecutor, and did the persecutor intend pick this person out because of one of those 5 grounds? And it had an immediate impact on the cases from Central America, which were still wending their way through the system. So it denied protection to young men resisting forced conscription into the military, fleeing guerrilla groups. And it's currently one of the central reasons, this nexus requirement in the US interpretation, for denying protection to individuals fleeing gangs or fleeing gender violence. And then in the late 1990s and the early 2000s, the US again rejected international norms in its interpretation of a particular social group, imposing a really restrictive and high standard that's resulted in the denial of protection to anyone in categories who can't fit in the other 4 grounds: race, religion, nationality, and political opinion. And so it's impacted children, individuals fleeing gender violence, gang violence, to name a few. And then, as I say here, that was all before Trump took office, right? So what I'm saying, and you know, I don't mean to equate the two and say that what happened before is means that what Trump has done is not horrific, but you know, it's a bigger picture. So what I want to do now, and I do want to leave time for dialogue, so I'm going to probably zip through even quicker. What I want to do in this last part of my remarks is go over some of the main policies that the Trump administration has adopted that have not just limited the promise of protection, but actually like taken a sledgehammer to it and tried to basically smash it into smithereens so that we no longer have any existing system. So I'm going to kind of quickly run through these, and they're in the order mostly, for the most part, chronologically of the order in which they were imposed. And so this is the list. I'm going to go through them real quickly. So, you know, metering was a policy by which first, you know, asylum seekers showed up at the border and Border Patrol would say, I'm sorry, we don't have the capacity to process you, so wait in Mexico. Not to be returned, not to be confused with the Remain in Mexico policy. And recently a CBP, Customs and Border Protection whistleblower, said he was instructed to lie and say they had no capacity to process when in fact they did have capacity. And this is just a image of the asylum seekers who organized themselves to put themselves on a list as who could enter when they were told that now there was capacity to enter. Then there was family separation. Again, I think you're probably all familiar with this. And even though it formally ended, it's still, the practice continues to this day. Then there was prohibiting asylum claims not made at ports of entry, notwithstanding the fact that the Refugee Act explicitly has language saying that you could apply for asylum whether or not you arrive at a designated port of arrival. There's a nationwide injunction against that. There's the migrant protection protocols, Orwellianly named. Most of us call them migrant persecution protocols or Remain in Mexico, which is basically refusing entry to asylum seekers. So if you show up, you're told remain in Mexico until your court hearing, until you are called for your court hearing. I'm going to go over these pretty quickly, but these are areas that are very dangerous where there's no support for asylum seekers. Even though individuals who are at risk in Mexico are supposed to be screened in, they aren't. Challenged in court. Injunction won against the practice, but that injunction stayed by the US Supreme Court. Second challenge to Remain in Mexico pending, but it's just that Remain in Mexico as applied to Tamaulipas, one area. Okay, and lots of documentation of the horrible things happening to people who are subjected to Remain in Mexico. Transit ban, prohibiting asylum for anyone who passes through a third country, and legal challenges. And in the interest of time, I'm not going to read everything on my PowerPoint because I do want time for, so just transit ban. What else? Safe third country, saying that El Salvador, Guatemala, and Honduras are actually safe so that the US could send asylum seekers to those countries, and sort of outsourcing the way that within the European Union, they outsource their asylum seekers to Turkey. This is the US doing the absolutely bizarre thing of saying that those same countries that are the origin countries for asylum seekers are safe. And under US law, they have to be both safe and have full and fair procedures in order to be considered safe third countries. And those El Salvador, Guatemala, and Honduras certainly are not. Being challenged in court, trying to end the Flores Agreement, which is protection for children. And again, I'm not going to read everything on my slide, but you can see that all of these, there have been legal challenges, either usually successful unless and until they get to the US Supreme Court. Detention of asylum seekers and an exceptionally high number of deaths in detention, at least a third this year related to COVID. Deporting, you know, with reckless disregard for safety, deporting infected or exposed migrants to countries that really don't have the capacity to provide health care to them. And then the sort of, you know, extreme measure of just totally closing down the border in March, using the pandemic as a pretext, and there's legal challenges. So just Attorney General decisions trying to limit protection, trying to interpret the law, trying to foreclose claims based on domestic violence or fear of gang, or claims based on family relationship. We've had some successes in the Ninth Circuit limiting matter of AB. This Diaz Reynoso case, which one of my wonderful colleagues argued. And we've had success in other circuits, and a shout out to my wonderful colleague Eunice Lee, who argued that First Circuit case. So we've had good things happen in the federal courts on some of these. And then we've had lots of regulations against sort of every aspect of law and procedure, trying to rewrite the refugee definition, trying to limit work authorization, charging fees on asylum applications, although there was a nationwide injunction just this week issued against the fees. So here's my last slide, and ending on a positive note here, which people who know me know this is my temperament is, so almost everything that I mentioned, the measures that I mentioned in the Trump administration, could be rolled back by a new administration. Executive orders, refugee admission numbers, detention policies, remain in Mexico, the border expulsions under the pretext safe third country. Those are all executive matters that could be rolled back. A new attorney general could certify and vacate those decisions, of which I just gave you the tip of the iceberg. There's lots more. And regulations that have been issued that haven't been finalized can be disapproved by a joint resolution of Congress, or new regulations can be promulgated, or we could get a new Congress and actually pass a Refugee Protection Act, which would make it impossible for regulations like this to survive, because they would be inconsistent with the law. So my last sort of thing to say here is, if you care about these things, one of the most important things you can do is to vote, because a new administration could do so much to turn these back. And I will, before I stop sharing my screen, I will just give you one last slide here, which is what I hope we will return to being, which is our ideal of being a country. We've never really met that ideal, but our ideal of being a country that welcomes those fleeing persecution. So sorry, I went a little over time in what the organizers asked me to do, but I think we do have about 20 minutes, so I will stop sharing my screen. And there we go.
Professor Musalo, thank you so much for that
Thank you so much.
Yeah, incredibly comprehensive view of asylum law, really from its origins to where we're at today. And that's exactly what we were hoping for this kickoff to the speaker series, to orient us where we are at today and where we've come from and where we might go. So I'm going to hand it over now to Emily Ellis, who's going to moderate the conversation, and she has some questions that she's going to start off with, but I see that we have several hands up, and so she'll call on you as soon as she asks some of the preliminary questions that she's outlined. Thank you.
Hi. Okay, so I think the first thing that I wanted to ask you, Professor Musalo, is you mentioned that there's this kind of negative perception of refugees among some of the population, with this view of them being kind of dangerous and a security threat or a drain on public resources. So even though there's lots of studies disproving this, how do we sort of get the message out and convince people of this so that we can put more political pressure on administrations to not have such restrictive policies?
Yeah, no, that's a great question, because I think the most important thing we could do is trying to change that narrative. And sort of, the current president has a very big podium, right? Very big bully pulpit, and he's got Fox News, magnifying a million times over. And I think we just need to be really good at speaking out, writing op-eds, appearing on programs, and really being spokespersons for this other view. Not let that narrative and that message, not sort of abandon it, but really be strong and understand how important messaging is to change the narrative. So thank you, Emily, for that question.
Yeah, and then I'm gonna give other people a chance to ask their questions now, and if there's time, I'll come back to more of mine. So I think Claire was the first one to raise her hand.
Hi. Yeah, I was really excited to see that you're challenging matter of AB, and I was wondering if you could talk more about like where you are in that lawsuit and like what your arguments are and how hopeful you are, because, you know, what a horrible decision.
Yeah, thank you, Claire, for that question. So, you know, the case itself, AB, is headed up to the Fourth Circuit. So maybe just so everybody's on the same page. So the matter of AB was a decision by the Attorney General. And so that decision ultimately goes up to federal circuit courts of appeal. But it's not, but there is, and so the case itself is on its way up. But in the meantime, and that's what I alluded to in some of the slides with other circuits, at the same time, the Board of Immigration Appeals has been denying cases just citing AB. So those cases give attorneys the opportunity to challenge the reasoning of AB. And that's what attorneys have been doing. And we've been, at the center, we've been very involved. And so at least so far, the Ninth Circuit, the First Circuit, and the Sixth Circuit have issued decisions that have really been quite critical and rejected, you know, central holdings of AB. And I think what needs to happen is that needs to happen in all of the circuits. And so if you have a case raising AB, look to see, has your, if you're in the first, the sixth, and the ninth, you could use that good precedent in your, in your case. And if not, you can look at the rationale in those published decisions as to what they say about AB. Why was AB wrong? And basically, I mean, if we had a longer time, we could go into it, but they lay out, if you look at those decisions, they lay out really clearly why they say what AB held is legally incorrect.
And then I think Sheila.
Hi, Professor. Thank you so much for your insightful talk. I really enjoyed it and learned from it. My question has to do with something you said at the start of your presentation with regard to climate change. And I'm curious about, as climate change becomes worse and worse, I imagine it will become a more common source of seeking asylum. And what do you do in a country where the administration doesn't even necessarily believe that human-caused climate change is real? How do you establish it legally as a well-founded fear if there isn't necessarily someone persecuting you, or if the administration doesn't believe it's a thing? How do you deal with that?
Yeah, thank you, Sheila, for that question. So maybe say two things to that. I mean, one is, I think that it is hard under our current refugee definition. It's not impossible, but I think it is hard to claim people who are really at risk of losing their life. They're just as much at risk as traditional refugees. But it is hard to make it fit to say they're persecuted on account of one of the 5 grounds. So on just a sort of a first level, I think the international community needs to come up with more, agreements and compacts and instruments that accept that people who are displaced and at risk because of climate change and related disasters, flooding, droughts, et cetera, get resettlement opportunities. But the second thing, I would just say that under US law, we do have this status called temporary protected status, which, it's not perfect, but it provides, set periods of protection for people who were already in the US when the conditions developed. I think TPS needs to be modified so that people could actually arrive here. And if they didn't, until we get a new refugee definition, people could arrive here. And if the reason for their flight was because of these factors, that they could get TPS. The way we have TPS now, you have to have been in the country when TPS is declared to get it. So it wouldn't allow people to enter. I just want to say quickly, the New York Times had a really good long piece about climate change about a month ago, and it focused on some of the Central American countries. And, New York Times sometimes not very progressive on issues, but the authors of that article really talked about how important it is that the international community recognizes the plight of these individuals and provides some route to protection for them. And I think we all, that's what we should be arguing for. So thank you again, Sheila.
Thank you.
Does anyone else have any questions they would like to ask? I see Pat Rodriguez has his hand up.
I think it's Philip.
Okay. I think they both did, but Phil, if you want to go.
Sure. Thank you, Professor Musalo. That was a really fascinating presentation, and thank you for being here. I was just wondering, what are some of the critical similarities, if any, between the Remain in Mexico policy and the Haitian interdiction program? It seems like it's really a complete bar on accessing the asylum process. So I'm wondering, in these two kind of similar policies, what do you think are some of the critical overlaps that we can learn from?
Yeah, I mean, they're different, but they're similar in effect of not allowing people to access the territory. But they're different in that the interdiction policy was saying, you don't even get in our system, you're not permitted to apply. We're just picking you up and returning you to the place of persecution. And it was justified to some degree by these agreements not applying in international waters, right? But the Remain in Mexico, these are people that are showing up, at our border. And it has to do with I don't want to get too technical, but both the challenge to interdiction and the challenge to Remain in Mexico, they hinge on the interpretation of different statutes. But for all practical purposes, they're very similar, putting people at, who are fear persecution at risk. But because they don't rely on the same statute, I wouldn't go too far as a lawyer to say, well, this challenge helps us with this challenge. But I think the similarity I would draw, and I said this earlier and I really want to underscore it, is the way that Clinton reneged on his commitments because he feared this surge. Is, I think a lot of us are watching and trying to figure out what's going to be the movement in Central America. And what are, forces of surveillance going to tell an incoming administration, and what might the Biden administration do? So there's actually a number of us who have been meeting now for about a month and talking to partners in the region to try to actually both identify, is there likely to be a big movement, and what are some strategies? And some of them go to, like the question Emily asked earlier, like, is there some messaging that we need to do also about the numbers and about capacity? Because I think that, Philip, I think that's where they're the most similar, the risk to a president who says he supports protection, but then, is afraid by what he perceives as big numbers. And I have to remind people, Obama, who was not good on immigration, but we all know not as bad as Trump for sure, but he was like frightened into restrictive policies when like 40,000 unaccompanied kids showed up the border, which should be nothing for a country like as rich and as big as ours. So you worry if there's large movements, what a Biden might do. So again, thank you for a really good question.
All right, I think Professor Lee was the next one to have her hand up in the chat.
Hi, thank you. Well, thank you, Professor Musalo, for that. You know how I feel about your work and your thinking and what you've done for the field. So my question, the last time I had an opportunity to talk to you, we were under different circumstances with regard to the Supreme Court and the composition or likely composition. And I just was wondering, given your experience pushing incremental change through the courts and how successful that has been, how do you see the changing composition of the Supreme Court, as well as kind of the federal courts in general, impacting the development of US asylum law?
Yeah, thank you for that question. And I want to hear what you think too, and so, I think it's frightening because look at the number of appointments that this administration has made and what the Supreme Court will be if Amy Coney Barrett is confirmed, unless the Democrats are elected and then have the spine to, in my own personal opinion, they should enlarge the court and it'd be totally justified. Merrick Garland was a stolen seat. This is like totally illegitimate. But then the courts, then I think in a way, it's more going back to Congress, more of the emphasis on, having Congress rewrite the Refugee Act and making clear what that definition should be, since we can rely less on the courts. But Professor Lee, I want to hear what you think, because Professor Lee's like a litigator supreme, and the kind of work that she's done over the years at the ACLU Immigrant Rights Project before she came and worked with me at the center, and as I mentioned, the DePena case in the First Circuit, which was a great trailblazing. So what do you think about that, the courts versus other branches of government?
I think I would mainly just agree with everything you've said and say, yeah, that Congress can change a lot of this. And if they do it well, they can do it in a way that would expand protections and keep in line the ones that we have, and in a way that keeps it out, out of the courts almost, or not up for debates in terms of interpretations of law. So that, and like you mentioned earlier, of course, the possibility of a new attorney general issuing, both rescinding precedent and issuing new precedent. And that, that could be another way, I think, which would also be fairly, as we've seen, or as you've seen, of course, when that happens, that also is a lot less vulnerable to challenge in the courts just because of the way that review is structured. But I'm going to toss that back to you again, just to say, in terms of having all of those cases and having that, bringing about that change both legislatively and through BIA AG precedent, that's been so much of the work of the center.
Yeah, I think I'm always at the philosophy of like, do as much as you can do on parallel tracks, right? Like, because you'll hit a barrier in one track and then you switch to another and then switch to another. And we have to, educate people. I think that, there's a lot of fear, fear that like people operate out of fear, and this administration has demonized migrants. And so I think that's part of the media, and the messaging is just as much as the three branches of government, because you're not going to get those three branches to do the things you want if the populace is going in another direction. So that's kind of, for me, always a big piece of it.
I think Bridget was the next one with her hand up.
Thank you so much. This has really been super thought-provoking. And there are some chickens nearby, so sorry if you can, they just started. But I think this year has been so incredible. Like, the Black Lives Matter movement has people talking about the purposes of detention and law enforcement in ways we haven't before. Nationally, and COVID has us talking about sharing resources differently. Like, an eviction moratorium would never have been something that would happen before this. So I'm wondering, like, what policies or concepts have kind of entered the chat in the immigration law community this year that didn't feel feasible before? Because that's like all I'm thinking about lately.
Yeah. I mean, I think that Black Lives Matter and really made it easier to make the point to people that so much of the immigration policy is rooted in racism, right? And I think to the degree that people are willing to start admitting just how deeply racist this country is, then accepting it in the context of Black Lives Matter makes it easier to sort of say, look, this is just an extension in the immigration area, and just go back to Chinese Exclusion Act, go back to the internment of Japanese Americans during World War II. You can see all these ways in which racism. So I think taking advantage of the fact that there's a consciousness of this to make arguments that are basically, you know, about respecting rights and norms and just not treating people like they're not human, like recognizing that. I know it's not like a particularly like ambitious goal, but honestly, where we are now, just recognizing that racism informs our immigration policy would be a big thing, because it's now like, it's about demonizing these are bad people instead of saying, no, it's not they're bad people, it's not they're dangerous, it's not that, it's because racism is like the locomotive for this. So thank you, Bridget, for that question.
And then I saw that Professor Lawrence, you had your hand up momentarily. Do you still have a question? No? Okay.
I mean, I have lots of questions. I have so many questions, but not right now.
Okay. So I think Daniel.
Yeah, thanks. Just repeating everything. Thanks for giving the talk, Professor Musalo. It's been a delight. My question is more about matter Kasenga. From what I know about the case, it was a very positive decision that came during a time when like sympathies, I guess, national sympathies weren't very pro-immigration. Like IRARA was passed around the same time. Well, so I guess how did you get a positive outcome, like such a critical outcome, at a time when, like, I guess there's a lot of prejudice against migrants and refugees nationwide? And like, are there any practical, I guess, are there any tips you have for us who maybe want to do the same?
That's a great question. Thank you, Daniel. You know, again, you guys are going to get sick of hearing me say this. I just say you guys because I'm from New York. It's not a gender thing, but you're going to get sick of me saying messaging, because what happened with Kasenga, the tide totally turned once we got the major media really on board and so sympathetic. So I'd been working on that case, and she was in detention. We'd been trying to get her out of detention with congressional intervention, everything. And nothing happened until we got first like an op-ed in the Washington Post, then a big article in the Washington Post, then a above the fold article in the New York Times. For those of you who remember when you used to read your newspaper in paper, and above the fold was really important. And within a week, she was out of detention after the New York Times. It was, the articles were so sympathetic. They were so sympathetic that the minute the articles came out, I started getting phone calls from around the country with people saying to me, what can I do to help this woman? And I would say, like, call the Attorney General, call your Congress member, call. And, you know, later on I learned, somebody who was on the Board of Immigration Appeals told me confidentially, they said, you know, the decision that was going to issue in that case isn't the decision that actually issued because of like the media and public sentiment. Now, I have a whole discussion with my students every semester. Should the media affect what judges decide? And it's a legitimate question to talk about. But, you know, it's clear that the restrictive xenophobic media is having an impact. And so, you know, to the degree that we can really use the media, but, you know, and I'll say one other thing, there's a little bit of the, you know, she was from Africa. And so for some people, they wanted to exoticize it. You know, they were interested in the story. And so that has its risks too. You don't want to sensationalize. So if you work with the media, you want to make sure you have like really responsible journalists who you can trust to handle something in a really respectful way. So that's just a little thing also I talked with my students about, you know, when if you're going to work with the media, how do you decide who you work with and make a choice as to who's really reliable to handle a sensitive story. But that's, you know, Kasenga, thank you for asking that question, because really it would not have ended up that way if public opinion hadn't just like upsurged, because you're absolutely right. Her case was the same year as the 1996 Immigration Act, which was like a, you know, an atrocity, right? And at the same time, there she goes. So the power of messaging, you know, and good lawyering and other things, you know, I will, but it all has to come together. Thank you, Daniel.
And then I saw that Professor Marcus had her hand up momentarily too. Do you have a question?
It's
yes,
so good,
hi.
Professor
Hi.
Marcus.
Hey, great to see you. So my question is, we got to get rid of MPP, remain in Mexico. We got to get rid of the barriers. We got to start processing cases. Are you involved in any conversations about that, like what we set up? I mean, I know that there have been some proposals. Doris Meisner, the former immigration commissioner, is part of like a think tank, and they put out something about we should have asylum officers do adjudications and you know, not have it in a courtroom setting. And we should, I mean, are you involved in any of that? Because that, like, if the rubber were to hit the road, do you have thoughts about how that happens?
Yeah, so thank you for that question, Professor Marcus, or Lynn to me. We've known each other for so long in the trenches. So, you know, there's like 2 or 3 or 4 or probably more tracks happening. So the Biden administration itself has convened these different working groups, sort of like transition team. And 2 of my CGRS colleagues are on some of those working groups. And then there's other groups that have been convened under the aegis of different foundations or think tanks. And so different groups are working up proposals that they intend to present to the administration, to have the administration sort of choose, giving the administration a menu of options. And then there's some of us who are starting to talk to funders and say, you know, one of the things that will prevent Biden from reneging is if he can be presented with, look, there's a way that this could be done without chaos and disorder that scares everybody. So there's those conversations, you know, happening. I'm not saying I feel assured that everything's going to run smoothly, but I do feel confident that people are really aware that these issues need to be discussed and some various models presented for the administration that would be ready to like put in place immediately. So thank you for that. That's a good question. I think we're all worried about what would happen in a transition.
Thank you for that answer. And then it looks like we have one more question from Pat Rodriguez. Do we have time for that? Awesome.
Thank you. Professor, I have a question. I have experience in some immigration matters outside from the US, especially from South America and Central America. And I know that many people that is living here in the United States coming from powerful politicians in those countries. So it's something that is possible to do a balance in a policy that, because some people really needs refugee here, needs help from us, but other people really not. In South America cases, some cases, not everybody, and Central America, most politicians coming from corruption to United States and buy here a lot, probably with a lot of money, that is from public money, coming here with fake evidence that they are, because political prosecution, or, you know, but they're really in the real life is not true. But it is like people that have money to do that can come here and get, but people like Central America people that this is very poor people, has no money, probably the doors from this country is closed for them. So I don't know how can I get balance in this new policy.
Yeah, so that's a really good question. I mean, my hope is that we can all work to make our system fair. And so what that means, a fair system would apply the law to every person equally. And, you know, somebody who really deserves protection would get it. And that in that process, if somebody, you know, isn't really at risk and they can't establish their claim, they're not given protection. But I think we all have to work to build back a solid, you know, workable, credible protection system. It's, you know, my position is not that every single person who applies for asylum should be granted asylum, right? But what we want is a system that provides for what our law contemplates, which is every single person who has at least a credible claim can be permitted to apply, and then and then have a fair system to determine which cases meet the standard and which cases don't. And hopefully that would meet the concerns that you raise, which are really, legitimate concerns. You want the people who most need protection to get it, and you don't want to see people get it who really they don't need protection and they're just sort of, buying their way into it. So let's all work to create a strong, just system, and hopefully it will result in, just fair outcomes.
Thank you, Professor.
You're welcome. Thank you.
Emily, I think we have a time for one more question. If you want to ask the last question, as our oh, actually, I see that Professor Harris has also raised her hand. So go ahead, Professor Harris.
Hi, I'm so sorry for having my video off. I've been parenting at the same time as listening, so I didn't want to have that chaos be distracting in the background. My question is something I've been looking at a lot lately, and thank you so much for that. I don't know how you did all of that in like 40 minutes, Professor Musalo. That was amazing, as always. One of the things I've been looking at is how attorneys are actually doing with all of this, how immigration and asylum attorneys are faring in levels of burnout, stress, vicarious trauma with all of this. And so I've done a national survey on this, and I may share the results in a few weeks when I speak to you all. But I was wondering if you could just share with us, as someone who has been in this fight for the long haul, how you kind of keep going, and how you are such a positive person and you are able to put a positive spin on it. Just any tips you have for this community in terms of keeping it positive and taking care of yourself so that you can continue to do the incredible, pioneering, innovative work that you have done for so long.
Professor Harris, thank you for those incredibly kind words. I'm a big fan of yours also. Like the amount of things that you produce, like every time there's a new regulation, you're out there giving everybody the resources to respond to it. I'm like, so, I mean, just a couple of things on that. I think it's so important for each of us to take care of ourselves, right? And to try to set limits, as hard as it is, and then to make time to do the things that are very rejuvenating. And for everybody, it's like different what gives you that energy and that healing. And, it's like I meditate, I exercise, I make sure and spend time with friends, I go for a lot of hikes. So, I really put a big value on community and spending time with like-minded people who really share the same values. I play with my dog, my cats, they all make me laugh. So, it's like everybody has their repertoire of what you do, but the important thing is to do something. The important thing is to know that you have to step away. You're not good. You're not going to be in it for long haul. You're not going to be good for the cause or your clients if you either get vicarious trauma or if you're burnt out, right? So you have to do it. And I'm really looking forward to Professor Harris's piece from this study, because one of the people she consulted with, Dr. Stuart Lustig, who's a great friend of mine, he came and spoke to my students this week, and he mentioned how excited he was by your study. So I'm looking forward to it too, because I'm sure there's some lessons in it for all of us.
Yeah, thank you. Thank you so much. As if on cue.
Emily, I think, and thank you so much for asking that question, Professor Harris. That's great for our community here to hear, Professor Musalo's response to that. Emily, do you want to, I think we have time for one last question if you want to ask one last question, and then we'll wrap it up. Wonderful conversation.
Emily, why don't you just mention that Lindsay's going to be, Professor Harris will be speaking with us.
Yeah, I'll do that at the very end.
Oh, okay.
At the very end.
Yeah, I'm going to just kind of segue off of that question about taking care of ourselves, but then into taking care of clients. I saw that you've done a lot of work with trying to bring psychiatrists into the asylum process and sort of providing more holistic care for people who have been through this trauma and are now faced with an equally stressful and complex legal process. I was just wondering if you could tell us like a little more about that, and if you think that we need to start looking at more holistic approaches to how we take care of refugees rather than just putting a stamp on some papers and saying you can stay.
Yeah, thank you. That's so important. I started working with mental health professionals with clients almost at the beginning when I started doing this work, and it wasn't out of any like real insights that these clients were traumatized and they needed help. It was more like these clients. I saw that they weren't being believed. They were in courtroom and they were describing horrible things, but they didn't show any emotion. And I was worried more about, is this client going to be found credible? So I started to talk to a lot of people and they said, why don't you just like send your client to a mental health person and see what's going on? And the mental health person, diagnosed post-traumatic stress disorder. And that's when it first like dawned on me that as I looked into it more and more, that so many of the clients are suffering, and the very nature of the reason they fled is because they were persecuted. They then have trauma, and that trauma impedes them in being able to tell their story in a credible way. And it also impedes them in trusting and working with their attorney. So I first came to it from a very utilitarian, like, I have a client, the judge isn't going to believe my client, like, what are the different things? But then when I got into it more, I realized that the client, not only do we need the mental health professional as a forensic expert to document, but the client is suffering so much. So the very process of telling the story is re-traumatizing. And so there's the need to then for the client to have the support and the therapy. So I now sort of think of exactly what you were saying, holistic, and it could be one therapy, there's lots of different like opinions on this, but it could be that the same mental health professional who provides therapy could do a forensic evaluation, or it could be that you have two, you have the one person who's treating and the one person who's doing the forensic. But it's important both for the client's health and for proving the case. And then I would take the third piece that I tell my students, and it's important for us because we're suffering from PTSD and we're getting the secondary trauma. And so we need to sort of, be in therapy or get the kind of mental health support. So yeah, it's a holistic, exactly as you said, there's like a holistic approach that recognizes the emotional toll that this work takes.
Thank you so much, Professor Musalo, for having this rich conversation with us. And thanks to all of you. Thanks very much to Professor Lawrence for helping to put together this speaker series. Also, all of the Immigration Law Student Association students who've been involved, Emily in particular, and Philip Rohde helping to put together this event today. And of course, to Professor Lee and Professor Harris for also facilitating our conversation. And to all of you for coming with your thoughts and your questions. This is very much meant to be a conversation, and we're so excited that we get to continue that conversation in 2 weeks on October 16th, same time, you'll have a different Zoom link, and hopefully we'll figure out the chat issue and nobody else will show up as me to that one. And she will be speaking on particular social group, which Professor Musalo touched on in her presentation, and some of the issues surrounding that have been more recent and come out of matter of AB in particular. And so she'll focus on that. And then we'll have Professor Harris round out the series for fall. And I hope you will talk to us about your study. And you're also going to talk to us about what it means what it means for asylum to be under attack in the current climate, but hopefully we can hear more about the trauma-informed lawyering in this area also. So thank you again, everyone, for being here, and I hope to see you all in a couple of weeks.
Thank you very much. It's my pleasure. Really my pleasure being with all of you today. It's great.
Thank you very much, Karen.
Thank you all.
Thank you.
Good luck. Good luck, everyone.
Bye.
Bye.